Today's episode is brought to you by Dr. Jeffrey Halstead, DMD. Dr. Jeffrey Halstead has been Canandaigua's hometown dentist for more than 35 years, offering routine dental care as well as cosmetic dentistry, implants, and dentures by their highly trained and experienced staff. Visit them online at canandaiguadentistry.com or find them on Facebook and Instagram. From FingerLakes1.com, this is FLX Today. I'm Josh Durso, and we are joined by Waterfront founder and reporter Peter Mantius to talk about a pair of environmental stories centered around landfilling, waste, and what's next for both. Peter, thanks so much for taking the time today.
Great to be with you, Josh.
So first things first, we're talking about Judge Doyle's decision to invalidate Local Law 3 in Seneca Falls, and then opponent's decision to appeal. Take us through what happened and where we stand now.
All right. Well, Judge Daniel Doyle, who was a state Supreme Court judge, ruled for Seneca Meadows, which is the state's largest landfill, as we know. He invalidated a town law that required the landfill to close by the end of 2025. Nullifying that law removes a major obstacle to the landfill's plan for a significant expansion. Seneca Meadows has applied to the state DEC for a permit for its so-called Valley Infill project, which would give it space to continue operating until 2040 at current dumping rates. I mean, I think it's a huge and I think surprising court victory for Seneca Meadows. And I'm sure it will be appealed, or I'm told that it will be appealed. It has not been yet, as far as I know, but expect that. The reason I think it's surprising is that Judge Doyle actually used the State Environmental Quality Review Act to give the landfill its win. Now, that law, which is nicknamed SECRA, was enacted to protect communities from being blindsided by projects that cause significant environmental harm. That is, to protect them from polluters.
Right. Judge
Doyle turned it around. He reasoned that in this case, the law must protect the polluter from the community and its law. Under SECRA, an entity that proposes to take an action that might have environmental consequences must take a, quote, hard look, unquote, before issuing a, quote, negative declaration, which is nicknamed a neg dec. A neg dec is a conclusion, really a judgment call, that the action will not have a significant negative environmental impact. Now, Judge Doyle found that the town board that enacted the law in 2016 failed to take that required hard look, and that the law must be canceled because of that failure. He said board members should have considered where Seneca County would send its waste if and when Seneca Meadow closed. Never mind that Seneca County contributes a small fraction of Seneca Meadow's waste stream, and never mind that the net effect of closing the landfill would be a giant win for the environment of Seneca County. But Doyle wrote, the mandates of SECRA must be strictly followed. And I just say, oh, really? The mandates of SECRA are regularly abused by both the DEC and companies seeking permits for projects that actually do net environmental damage. And New York courts have been very permissive in allowing SECRA rules to be stretched or broken. How strict was the court when it considered the neg dec the DEC awarded to Greenwich Generation in 2017 to restart its power plant in Dresden? The DEC knew that plant did not have a water intake permit or fish screens required under federal law. The DEC knew Greenwich's unlined coal ash landfill was polluting Keuka Outlet. The DEC granted the neg dec anyway, prompting a lawsuit from the Sierra Club. The court sided with the agency and the polluter. That neg dec was just fine. And where were the courts when the DEC issued neg decs for Cargill's giant salt mine under Cayuga Lake? Independent scientists warn that a catastrophic roof collapse or mine flood is not only possible, it may be likely. Lawsuits brought against those neg decs also lost in court. I think if Judge Doyle's decision stands on appeal, the bottom line is the courts enforce unequal treatment. Deep pockets like Cargill, Seneca Meadows, and Greenwich are treated deferentially. If Doyle is upheld, we will know that SECRA may be applied strictly, so long as it does not interfere with major corporate interests. Don't expect that strict enforcement standard to apply to the Cargills and the Greenwiches of the world. So that's my little kind of editorial on all this, but I think the courts are being very inconsistent in how they are treating the SECRA law, at least in the Finger Lakes. I don't know about the rest of the state, but from my experience in the Finger Lakes, I see just tremendous difference.
Yeah, it's interesting too, because another caveat, I go back to the days when I covered town and county boards. It was always interesting to me that the SECRA process, it felt a bit above the pay grade of most town board members or county board members, just given the amount of time that it would seem to take to really be able to hammer out all of the details and flesh out all the details of the the long-term environmental impact of some of these projects. So what's your take on that, I guess? And then also as that sort of parlays into the way the courts are kind of inconsistently ruling. Could it be a reflection of that? Maybe the courts or the state having this feeling that, the SECRA process isn't exactly perfect, and the way it's executed in some communities, it just isn't equal. So outcomes aren't always equal.
Well, I think that the the courts tend to defer to the DEC. I think that they're reluctant, and I can understand why a judge might be reluctant to say, well, I'm going to weigh in here, and the DEC they're the experts, but I'm going to Bigfoot the experts. I'm going to say my judgment is better than the experts. I think they're reluctant to take that stand. But I think if you really read what SECRA requires, it is not applied, and it is just blown off in many circumstances. And polluters realize that they want to avoid an environmental impact statement because that brings the public into it. It brings much more data into these cases. And that's the magic of a neg deck. If they get a neg deck, they get to sidestep the environmental impact statement that brings the public into the process. And that's why Cargill, for example, has never had an environmental impact statement on that very risky mine under Cayuga Lake. Because they've managed to get obtain these neg decks from the DEC. And Greenwich also, it had a number of environmental issues that were just, very much needed to be explored. They were all sidestepped, no environmental impact statement.
Yeah. Expansion permit with the DEC. We know it's, I guess, in progress. Any indication? Obviously, a lot of folks thought that invalidating local law 3 would be a pretty significant step forward for Seneca Meadows and being able to get that permit approved through the DEC. Do we have any idea where we stand in that process, or how much more time may pass before the DEC actually renders a decision? And will there be any public meetings along the way? It seems like there would have to be, right?
I think, first of all, I don't have any inside information on where the DEC stands on this, but the DEC is requiring an environmental impact statement on that expansion. So that's good. Anyway, I don't really have any information on where the DEC stands on it.
Yeah. So let's shift gears and talk about this story that you wrote a couple days ago about sewer sludge, which to some people might seem a bit strange. But walk us through what these Steuben County towns are doing, why they are doing it in relation to Casella's idea to import sewer sludge from Long Island.
Right, right. Well, sewage sludge has been spread on certain fields in New York for many, many years. And one of the three big places in the state where it was done is this Leo Dixon uh, family operation in Steuben County. It it is the towns of Thurston, Cameron, and Bath. The 2,700 acres at issue here sprawls out and is part of each one of those towns. Now, Casella came in and either acquired or leased the 2,700 acres from the Dixon family with the intention of continuing the sewage spreading, which has become very controversial since Maine banned the practice last year. It banned it after it found that a number of dairy farms or farms were totally contaminated with PFAS forever chemicals. And this was in the soil, it was in the water, and it was even in the blood of the farmers. And so what happened was several farmers had to, well, they went bankrupt. They had to pour out their milk. They had to, in some cases, animals were destroyed. A very serious situation. So Maine had required testing and limits on PFAS in their sludge, but they were finding that those limits were exceeded so often. They just said, no, let's just ban the practice entirely. No more spreading sewage sludge anywhere on a field in Maine. Now, Casella is not allowed to do it in Maine, so it does want to try to do it in Steuben County. And what they want to do in Steuben County, they would not be allowed to do. It would be illegal in Maine. Casella has now applied to the DEC for a permit, or to have the Dixon's spreading permit transferred to it. And it has also applied to amending that permit to add a giant new source from Long Island. Right now, the Dixons are permitted to take sewage sludge from 28 wastewater plants around the southern tier and some in northern Pennsylvania. But this plant on Long Island is really big. In fact, it's as big as all of the 28 put together, roughly. So it's a huge new source, and this has caused a big stir. So first, the town of Thurston, and now Cameron and the towns of Bath have enacted 1-year moratoriums on expansions of waste projects. And that's where we stand right now. And Bath just became the third town to pass the moratorium just a couple of days ago.
And we were talking before we came on here, I threw the question to you, how common is this in other states? And you brought up Maine, but you also brought up another example, California, where apparently this is common and maybe encouraged.
Well, there are other examples. First of all, this is done all over the country. Sewage spreading is not just New York or Maine. And in Michigan, there's a really good video or it's a 42-minute video on a problem of a farmer there who had his entire farm just taken away from him. All his animals were destroyed by the state, again, because of high PFAS. And so it's a problem there. It's a problem in many other states. However, it's complicated because in California, there's an emphasis on keeping the sewage sludge out of landfills in order to keep landfills, keep their greenhouse gases down, and to prevent other issues of taking sludge to landfills. They are actually leaning toward encouraging spreading. So it's a complicated situation. Yeah. And in fact, New York is now going to be encouraging spreading. A new draft waste plan that takes the state's planning to 2050 calls for a dramatic increase in the sewage sludge spreading around the state. But I don't think that plan contemplates the possibility that towns like Thurston and Cameron and Bath say, we don't want this. So we'll see where it goes. It's going to be a very interesting political fight because the Hochul administration wants to increase sewage spreading, but I think that the news of how serious this is as an environmental hazard is going to create a lot of blowback on a local level.
Is Bath presumably the last town that would take such a step as an 1-year moratorium?
Right, because it's those 3 towns that are affected by this Dixon property that has now been sold or leased to Casella. So gotcha. That's the hot spot right now. But I will say also that the state has been very, very slow to analyze whether this sewage sludge is bad or not. How bad is it? How much testing is done? They're saying they want to greatly ramp up spreading on farm fields where crops are grown, and yet they're not testing to find out how serious the risk is.
And my last question for you on this one is related to those. It's a 1-year moratorium, so they would have all of these towns would have to come back next year, do the same thing if they wanted to extend it again, correct?
Yeah, or they could pass laws saying we don't want certain things in our community. Now, it's not clear whether they could stop people from doing what they've been doing all along, or whether they would only have the legal authority to stop new projects. I don't know the law on that. Yeah, but I think they want the moratorium so they have time to figure out what are the legal nuances. What can we do to stop or at least limit the expansion of these projects?
Could Casella challenge these local moratoriums, or would that just be too cost prohibitive to really go down that road at this point?
Well, in each case, each one of these towns thought about that. What happens if we get sued by Casella? Yeah. But the home rule in New York State is fairly potent, as the frackers found out. Home rule can be very potent, and it can really be difficult to challenge or to win.
All right, Peter, appreciate the time as always. Thanks for taking it today.
Okay, Josh, good to see you. Thanks.